let me say without any equivocation that there would not have been any need for a state of emergency to be declared in Rivers State. I live in Port Harcourt. I move around Port Harcourt. The state is peaceful and has remained so. So in the first place, there wouldn't have been any need to call for a state of emergency or to declare a state of emergency in Rivers State. In the first place, let me say that, yes, a state of emergency can be declared in the Federation or any part thereof, going by the provisions of Section 305 of the Constitution. However, it does not warrant the suspension of the governor, deputy governor, and other democratic institutions. Don't forget that this is not the first time a sitting president is declaring of a state of emergency. Jonathan did the same. And no part of the ambit of the government was suspended. So it was unconstitutional for the president to overreach himself by declaring a state of emergency and suspending the governor, the deputy governor. Now, we have a sole administrator, a military sole administrator, so to speak. The sole administrator again is overreaching himself by dismantling the democratic institutions. Just this morning, he has gone ahead to appoint sole administrators of the local governments. He has gone ahead to appoint members of RESEC. These are unconstitutional actions being taken by the sole administrator, and which is not even covered by the Gazette. By the Gazette, wherein the powers and the duties of the sole administrator were circumscribed. In fact, Article 3 of that Gazette says, the state shall, for the duration of the emergency, the offices of the governor, deputy governor, and House of Assembly are hereby suspended. That was the only aspect of the governance that was suspended, no other than that. In fact, that was Article 3 says, the state shall for the duration be administered by Vice Admiral Ibok-Ette Ibas, retired, as administrator, who shall operate on the basis of such regulations that may from time to time be issued by me. In other words, he is not to take any action that is not covered by any regulation coming from the office of the president. As at today, we are not aware of that the president has issued any regulation mandating him to dismantle all democratic institutions and even appointing some others in their stead. So for me, his action is unconstitutional and does not portend well. Rivers State is a peaceful state, and he has even said so himself. I mean, the sole administrator. So all this that he's doing, I do hope, will not lead to a breakdown of law and order, because we want peace in Rivers State. He came to Rivers State and saw that the place is a peaceful state, and we want to keep it so. let his actions and the way he's carrying on not lead to a contrary situation. That is very, very true. The Constitution made no provision for the appointment of sole administratorship. And even the Supreme Court said so. And if you recall, when the governor came back, because of the pronouncement of the Supreme Court in the judgment that they delivered, now urged all the council chairmen, all the councillors, to please abide by the decision of the Supreme Court. And they all vacated their positions, and their positions were taken over by the most senior officers in the various local governments, in keeping with the decision of the Supreme Court. Now, what this portends, this appointment of sole administrator, is antithetical to the decision of the Supreme Court. It is antithetical to the provisions of the Constitution, and it does not portend well for democracy, it does not portend well for justice, it does not portend well for the good order of the state. And it is not too late for him to retrace the steps so that we can continue to enjoy the peace we are enjoying in this state. This state is peaceful, and we want to keep it so.
So as someone in the middle of the law, so what would be your advice to him?
Well, you know, when I don't know the brief he has from the president, but the law is clear. He's overstepping his bounds. Even yesterday, the Federal High Court here sitting in Port Harcourt, in suit number FHC-PS CH 46-2025, PLEX Center for Civic Education, again the sole administrator, issued an injunction restraining him from appointing caretaker sole administrators. But the sole administrator has, contrary even to the injunctive orders given by a court of competent jurisdiction, flouted the order of the court. And I think it is for him to respect the rule of law, to respect the decisions of the court, such that our country, our state, will be seen not to be a lawless country, not to be a lawless state, but a state governed by rule of law and order. Therefore, my advice to him, if we will listen, is for him to please retrace his step. Because even the National Assembly did not donate such powers to him. The National Assembly that approved the proclamation that was made by the president did not donate such powers to him. And I think it is high time the National Assembly as well should call him to order, such that they will be seen, the National Assembly will be seen as well as obeying and keeping to the rule of law and enforcing same, because they were the people who gave a stamp of authority to the proclamation made by the president. So it behoves on them, now that the sole administrator is going the way he's going, to call him to order, that is going beyond his bounds. So my advice to him is to please retrace his step. And for Rivers people, if I may say so, is to be peaceful and law-abiding, because we are in trying and tempting times. That is my advice.
Thank you.
Thank you.